This is a great question, and it's really important to understand how parental responsibility has changed since the May 2024 amendments in family law. May 2024, we saw some of the biggest changes in family law in almost 20 years. Just for reference, I'm a family lawyer based in Brisbane. This question is super relevant in relation to those changes. To get the answer to this question, I'm going to reflect on how things were prior to bring you forward to understand how things are now. Before these changes that came into place in May last year, there was a presumption of equal shared parental responsibility. Now, this presumption applied to every matter. You had to override the presumption for this not to occur. Now, the term equal shared parental responsibility often got confused with people assuming it meant equal time. It didn't mean equal time. To override the presumption of equal shared parental responsibility was no easy feat, but it did occur, particularly when there were significant risk issues in relation to the child. Parental responsibility is all about those long-term decisions that parents make in relation to a child. So it's things like the child's education, a significant health event in relation to the child's name, the child's religion. It's these sorts of things. Parental responsibility does not relate to the day-to-day tasks in relation to caring for your child. Parental responsibility doesn't mean you have to ring the other parent when you have to make a decision. Say your son fell over and scraped his knee. You don't have to ring the other parent to say, can I put a band-aid on his knee? No, it's about the long-term decisions. What happened prior with equal shared parental responsibility was that if the presumption was applied, the court then had to look at whether equal time was an appropriate arrangement. Was it a practical arrangement? Parenting matters. This area of case law did evolve over time. So towards the end, we were seeing a lot less of equal time arrangements being put in place in family law matters because often they just weren't practical or they weren't seen to be in the best interests of the child for different reasons. If an equal time order wasn't appropriate, then it was whether a significant and substantial time order was appropriate. This was more than the Disney dad type of thing that used to occur prior to all of those changes. So a significant and substantial time arrangement was about the child living with one parent and then the child spending time with the other parent, say on the weekend. It might be from Friday to Monday. It includes, say, an afternoon on the alternate week or on both weeks, or some time after school for a few hours, and it would include holiday time, maybe more time in the holidays as well. The idea of the significant and substantial time arrangement was so that parents were encouraged to be part of that daily life and routine of the child, not just be there for the fun stuff on the weekends while the other parent had to carry that burden of doing all of that stuff with the child. So it was for the child to see that parent involved in their daily life and their routine. That might have meant that they had to partake in taking the child to an after-school activity, helping the child with their homework, or helping them with their bathing routine and their showering and so on, so they're ready for school the next day. In May 2024, the law has changed. As a parental responsibility, there's been massive changes since May 2024. Even if a matter goes to trial now, the judges do not have to make an order in relation to parental responsibility. There's no statutory pathway now requiring the courts to make a decision in relation to parental responsibility. For interim orders in relation to parental responsibility, it's also not common for those orders to be made unless one parent is making some very silly decisions. Very unlikely that interim orders around parental responsibility are made anyway, particularly when they might be overrode later on at a final hearing. At the interim level anyway, the court can't make findings of facts or in relation to the credit of a party either. I hope this information's been helpful. Please follow me for more legal TikTok. Please comment. I'd love to hear your thoughts. And please share this with a friend if you have found this information to be useful for you.